Hello everyone. In this lecture, we are going to begin to consider Actus Reus. Before you begin to study individual offences, it's important that you understand the general elements that make up each of those offences. Actus Reus is often described as the physical element of a crime or wrongful act. This is a good way to begin thinking about it. It is important, however, to keep in mind that an Actus Reus includes much more than simply just an act. In fact, Actus Reus comprises of all the elements of the offence other than the state of mind of the defendant. So, all offences must have an Actus Reus, and, very importantly, all the ingredients of the Actus Reus of an offence must be established. The two cases that best illustrate this point are Dadson 1850 and Della 1952. In Dadson 1850, D, a policeman, shot and wounded V whilst trying to prevent V from stealing wood from a copse, which is a small woodland. Under Section 39 Lancery Act 1827, stealing was a felony in circumstances where an offender had two previous convictions for the same offence. V's previous convictions brought him within this definition. V was therefore a felon. This is significant because at the time it was lawful for a constable to shoot a felon in the process of committing a further crime. D did not know, however, that V was a felon when he shot at V with the intention of causing grievous bodily harm. It was held that D could not rely on the fact that it was lawful to shoot a felon in the circumstances in which he shot V if he was not aware of the facts justifying his actions at the time of the offence. So, the fact that D did not know that V was a felon meant that the Actus Reus for the offence of lawful shooting was incomplete. In order to establish the Actus Reus of the offence of lawful shooting, the two elements of the Actus Reus had to be established. That is, that V was a felon and that D knew that V was a felon. It was possible to establish V's status as a felon, but not D's knowledge of V's status as a felon at the time of the shooting. As this element of lawful excuse could not be established, the Actus Reus was incomplete and D was therefore guilty of the offence of grievous bodily harm. In Della 1952, D was charged with the offence of false pretence, now fraud by false representation, when he persuaded V to buy his car by telling V that he was free to sell the car and that he did not owe any money on it. D thought that he was lying to V, as he had previously signed an agreement with a finance company which, in effect, amounted to the sale of the car to the finance company and the leasing back of the car back to him. In fact, the loan on the car was void for technical reasons. The loan therefore did not exist in law. D had accidentally and with dishonest intent told the truth. He had not made a false representation. He really did not owe any money on the car, and he was therefore free to sell it if he wanted to do so. Therefore, no unlawful act had been committed. D had intended to commit a crime by making a false statement, by lying, but circumstances meant that he unintentionally told the truth. You see, no one can be guilty of an offence for simply having guilty thoughts or because they believe themselves to be guilty. The mens rea alone, in this case his intention to make a false statement, cannot be sufficient to create liability if the Actus Reus is incomplete, regardless of D's dishonest and disreputable intention. Isn't that fabulous? It should be established that D is responsible for a specified conduct or the existence of a state of affairs. It is not always possible, however, to separate the Actus Reus from the mens rea. Sometimes the Actus Reus and the mens rea overlap or seemingly inhabit each other's territory. Our attempts to separate the elements of an offence in this way are simply a means of easy analysis. So, if, as you continue your study of criminal law, you find that an offence doesn't quite fit this formula, you have not necessarily misunderstood the issue at hand. In these circumstances, you are simply required to establish that all of the elements of the offence have been proven as a whole. There are many examples of this throughout criminal law, but the following examples should help you to understand the concept. False representation and the element of knowledge. In order to establish the element of false representation in the actus reus of the offence of fraud, it must be established that D knows that what he is representing as fact is actually untrue or misleading. You see, it is this knowledge that makes what he is asserting into the actus reus of the offence of fraud. The concept of knowledge amounting to an element of the actus reus of an offence can seem confusing, as it is something we would usually think of more of a fault-based element, and therefore as part of the mens rea. In this example, however, it is being used to define the term false. So, what is D's actus reus? He is making a false representation. How do we know the representation can be defined as false? We know because it has been established that D knows that what he has said is untrue or misleading. If it can be established, therefore, that the statement is in fact untrue or misleading, and that D knows that the statement is untrue or misleading, the actus reus of the offence will be established. The definition of an offensive weapon and the element of intention. It states in the Prevention of a Crime Act 1953 that an offensive weapon means any article made or adapted for use for causing injury to the person or intended by the person having it with him for such use by him. Suppose two men are walking down the same street and each man is carrying with him a large carving knife. They are mirror images of each other, one man's actions completely undistinguishable from the other man's. Only one man, however, has the actus reus of an offence and is therefore considered to be carrying an offensive weapon. You see, only one man is carrying the knife with him, intending to use it to cause injury to another. The other man is carrying it for a lawful purpose. Perhaps, for example, he is a chef on his way to work. It is the intentional use of the article, in our example the knife, that determines whether it is defined as an offensive weapon, not the simple possession of it in a public place. Without this intention, it cannot be regarded as an offensive weapon. If it cannot be regarded as an offensive weapon, the actus reus of the offence cannot be established. In Boyson, 1982, D was searched by a police officer and found to be carrying a polythene bag containing traces of cannabis. The amount was so small that it was unlikely that it was of a usable quantity. It was held, however, that Section 5, Misuse of Drugs Act 1971, created an offence of possessing drugs, not using them, and a person was guilty if he had in his possession any quantity, however minute, that was visible, tangible and measurable. If, however, D's knowledge cannot be established, perhaps because the quantity is so small it cannot be proven that he knew it was there, then he cannot be held to be in possession of it. It is not possible to be in possession of something if you do not know of its existence. The element of knowledge is therefore a component of the actus reus of the offence of possessing a controlled drug. The definition of the actus reus of some offences includes the existence of a particular state of mind on the part of the victim. An example of this is the offence of rape. In order to establish the actus reus of this offence, it must be proven that V did not consent to the act. If this cannot be proven, the actus reus cannot be established. Absence of consent here, therefore, is a legally relevant circumstance. So, you now hopefully have an understanding of how essential it is that all the elements of actus reus have been established. Let us now look at types of actus reus. Conduct crimes. Conduct crimes do not require any proof of harmful consequence or any specified result to occur. All that needs to be established is that D has engaged in the prohibited conduct. Let's have a look at some examples of conduct crimes. Fraud by false representation. If D makes a false representation, the actus reus of fraud by false representation is complete, regardless of whether anyone believed him or acts upon the representation that D has made. Dangerous driving. Under Section 2, Road Traffic Act 1988, it is an offence for a person to drive dangerously on a road or other public place. All that needs to be established is that D has driven the vehicle dangerously. It is not necessary to establish that his actions caused injury or death to anyone or any damage to the property. Perjury. If D makes a statement in court on oath, knowing or believing it to be untrue, it is not necessary to establish that his testimony influenced the outcome of the case, or that it was even believed. It is only necessary to establish that the statement was made. The second type of actus reus we are going to look at are legally relevant circumstances. The circumstances that surround D's conduct, or which constitute the state of affairs, may determine whether that conduct is categorised as lawful or unlawful. Examples of legally relevant circumstances include the offence of rape. In the offence of rape, it is the circumstance of V not consenting at the time of penetration that makes the lawful act of sexual intercourse into an offence. Burglary. In the offence of burglary, the relevant circumstance is that D must have entered the building or part of the building as a trespasser. Bigamy. The circumstance of being legally married makes entering into a new marriage a crime. The next type of actus reus we are going to look at are result crimes. Result crimes will require that a particular harm or consequence occurs as a result of D's conduct. Examples of result crimes include causing death by dangerous driving. Under Section 1, Road Traffic Act 1988, if D causes the death of V by driving dangerously on a road or other public place, he is guilty of an offence. Criminal damage. The actus reus of criminal damage requires that D destroys or damages property belonging to another. So, if the property is not destroyed or damaged, the actus reus cannot be complete, regardless of D's actions. Murder. The actus reus of murder requires that D's conduct causes V's death. The offence of murder, however, also includes elements of unlawfulness in its actus reus. It is therefore not enough for D to have caused V's death. He must have done so without lawful excuse. Accordingly, if D causes V's death, but D and V were soldiers at time of war, or if D acted in self-defence, the actus reus of the offence cannot be established. The last type of actus reus we're going to look at are state of affairs crimes. There are some crimes that do not require the proof of any conduct on the part of D, or any harm or consequence to result from his actions. In fact, they do not necessarily require that D does anything at all. They simply require that a state of affairs, a situation, exists for which D is deemed responsible. An example of this is being found in possession of a prohibited substance or being found to be without the correct documentation. The being found element of state of affairs offences is illustrated in the cases of Lansner 1933 and Windsor v Chief Constable of Kent 1983. In Lansner, D, a French woman, was convicted under the Aliens Order Act 1920 with being an alien, a non-UK citizen, to whom leave to land in the United Kingdom had been refused. This essentially meant that she was in the United Kingdom without the correct papers or necessary permission. However, she did not come into the country voluntarily. She was brought into the United Kingdom against her will whilst detained in police custody. Regardless of this, the state of affairs of being in the country without permission or papers existed. She was therefore found guilty of the offence. In Windsor, the police were called when D was found slumped in a hospital corridor. He had been seen by a doctor earlier in the evening, who had declared him to be drunk and fit to leave. On arrival, police officers attempted to speak to D, but he was unable to respond. So they placed him in a police car and charged him with being found drunk on the highway, contrary to the Licensing Act 1872. D contended that as he had been carried to the police car, he could not legitimately be said to have been found on the highway, and that, in any event, he was only on the highway very briefly. It was held that D fell within the Licensing Act 1872 if he was, as a matter of fact, present on the highway and perceived to be drunk, notwithstanding that his presence there was momentary and not of his own volition. In addition to the above types of actus reus, conduct, legally relevant circumstances, result and state of affairs, some actus reus consist of omissions. I look forward to discussing omissions with you in our next lecture. See you then.